Hey, Ketchum, this hearing is being conducted by Zoom. Mr. Ketchum's attorney is Dennis Kirk, during his office, and represents the state's assistant prosecutor James Rader, prosecutor's office on Zoom. This is an evidentiary hearing on probation violation. Mr. Kirk, you talked to the client and agreed to have this hearing conducted by Zoom rather than in-person hearing.
I have, Your Honor. It's okay with that.
You all right with that then, Mr. Ketchum? All right. The record reflects the defendant was placed on community control back on March 7th, I believe, of 2018 on a grand theft motor vehicle, attempted grand theft motor vehicle, 453 felonies. There's been a previous violation and continued on community control on January 30th, 2019. And there's a notification that has been filed on June the 3rd of this year that alleges that the defendant violated those conditions from those previous orders. Actually, it's March 7th, not March 5th. Whatever they said, right. March 7th of 18 and January 3rd of 19. Allegedly violated Rule 2 on or after 3.5 points failed to report, and Rule 15 after, or he has not made any payments on the courtrooms. And that was filed by Mr. Balser. The probation department was also on this hearing by Zoom, his office. Now, the court notified Mr. Ketchum of that application, appointed Mr. Kirk to represent him. The original hearing, I think, was set last week, and he continued this purpose. In another court, social meeting till today. Now, Mr. Kirk, we had an opportunity to review the allegations in the notification of the client.
I did, and I also was referring to the hearing that we should make that regular hearing into the violations.
All right, Mr. Ketchum, under the law, we have a right to have a hearing on this matter, which the state will have to present evidence through witnesses that proves the court that you have committed these violations. You have a right to have your attorney cross-examine those witnesses. You have a right to present testimony on your own behalf. Now, in the event that it's found that you have violated these conditions, whether it be by your own testimony or by your own commission or by testimony from witnesses, one of three things can happen. One, I can continue your community control in the same conditions originally ordered. Two, I can continue with additional conditions I think are appropriate, including extending it to a total of 5 years. Or three, I could revoke your community control and send you to prison for 18 months on the first count and to 12 months on the second count, consecutive for a total of 30 months, and fine you $75 or up. Now, you understand your right to hearing? You understand the consequences if it's found that you have failed to comply with these conditions?
Yeah.
And anyone promise you anything or threaten you in any way to get you to make these admissions?
Yeah.
You're doing this voluntarily.
Yeah.
All right. So then you understand the allegations?
Yeah, I do.
And you admit or deny those allegations?
I admit.
All right. Anything from the state or the probation department regarding disposition?
Yes, Your Honor, we have to say, as there is that provision, sorry about the program, Mr. Ketchum, failed to comply with that, certainly did provide order to be control, he violated their sentence to STAR, leave STAR, and then they are again on another violation that we report. In addition to that, they also still with restitution in the amount of
Ketchum, anything you'd like to say? Well, I say at the time of the original investigation, that Mr. Ketchum reported that he was not being prescribed any medications for mental health issues, although he said he had a history of depression and bipolar disorder, which there's no evidence in the file of that. He failed to provide any documentation then. There's no evidence before the court as to the defendant's current situation. The only thing I can say, the only thing we know is that it doesn't pay court costs. The restitution is not paid, although it's not part of the application. And it was 2 years ago that we issued the warrant, June the 11th of 2020. Actually, I signed on June 10th, got filed on June the 11th of 2020. And I think that had a previous history of that was failure to comply on his intervention legal conviction. Granted that originally, and the order to arrest him was issued on October 23rd, 18, and was arrested on that until January 15th of 19, so he was barred for several months then. To that time, the court ordered him to start, which he did complete, which would have been probably, I would guess, somewhere. When did you get out of STAR, Mr. Ketchum? November. Okay. All right. And this case was also a transfer case from APA when the state terminated the probation services in the court. County had to take those over, and the indication in the report that when he was turned over from them, his file turned over, he was listed as being on then. And it was March 25th, 2020 that it was turned over. The letter said that his last time the president was returned. So, really, the court feels real same way circumstances here, other than the defendant's refusal to cooperate. Therefore, it's ordered the court that the control be revoked. And it's ordered that defendant be sentenced on count 1 to a term of 15 months, and on count 2 a term of 9 months, correcting 7% or in Ohio. Those are ordered to be run consecutively to each other for a total of 24 months. The court finds that the conduct occurred over a course of one or more course of conduct. One single sentence was not accurate about the seriousness of the conduct. The court also finds that his criminal history and his conduct while he's been in control is such that it's necessary to protect the public from future crime, but it doesn't appear that he has the ability to obey the law. According to the jail, it is 119 days of jail time credit, and Mr. Balser, you know how many days he had in STAR? You know how many days you did in STAR, Mr.
27.
Alright, well, I will confirm that. So you get credit for those two numbers, so that'll be somewhere over 250 days, something like that. Now, upon completion of your prison term, it is optional under the law, and the adult parole authority could, if choose to do so, put you under post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer in terms they set, and then during that period of time they determine that you have failed to comply, they can return you to prison, even though you served the entire term worked by the court for an additional period of up to 9 months for any one violation, but there is a cap of prison term, which is opposed to 24 months for all violations, but a new felony on post-release control supervision. then in addition, whatever sentence the judge in the new case could impose, that judge could also order you to serve an additional period of 1 year, or whatever time that long, which was over greater, be served consecutively to the sentence in that new case. You also order to pay the court costs, which judgment, granted, and execution is ordered, and if you do not pay those, then the clerk collect that through various means, including levying on bank accounts, wages, and other assets. If that doesn't collect, then on completion of your prison term, not while you're in prison, court could order you to be service to your credit for each hour you work, and an hour rate set up for work. Each hour you work, reduce your judgment by that amount until paid in full. Now, you're also still required to pay the restitution. That's not going to go away, and they can try to fight back and bring you back to court. And if you fail to pay it and it's shown you have the ability to do so, then you could be put in jail. Mr. Ulster, if you would contact Star and then let Mr. Boyer know what days are Star. So I still did in the answer. All right, is there anything further from council? All right, we remain back in custody, Mr. Beckman. All right, now, turn out to jail.
Yes, sir.
Yes.
All right, are you Tara Adams at the jail? All right, this is set for case number 210117. State of Ohio versus Tara L. Adams. The attorney in jail or attorney is Dave Wagner, attorney from his office, also attorney out of the state. This is Assistant Prosecutor King. Now, the defendant in this case entered a plea of guilty to lead count 1, possession of heroin, a fourth-degree felony. And the matter, that was back on October 21st of last year. The matter was set for sentencing on November 18th. Defendant failed to appear. The warrant was issued on the 19th. And she was picked up on June 14th. So the court then set the matter for sentencing today. Now, the court then became aware that she was indicted on case number 210195 back on December 7th on the charge of failure to appear. She's not been framed on that. And so, Mr. Wagner, she did fill out her request for counsel. Is everything on this form she filled out? Ms. Adams still correct?
Yes, sir.
All right. So the court will find then that she is entitled to appoint counsel on appointment Mr. Wagner to represent her. Now, Mr. Wagner, are you aware of this new charge?
I wish I was speaking on actually spoken on the charge. Yes, I have read.
All right. And do you wish to have the indictment read?
No, I did not get it unless we have a big meeting back.
All right, thank you. No, you can't say anything yet right now. All right. Court is holding her without bail in the other case. But I'll hear any out taken on bail from the state attorney in this case.
Given that there were not things in place since November of last year, the state has probably set some
Wagner?
If I may, not yet, myself, bail may dovetail the pitch that I made to the court as far as what I asked for sentencing. We've been asked for a little more in this case, under maybe potential sentencing. Next case, Microsoft bail can decline it. Bigger my argument.
I'm not.
Okay.
All right. Bond will be set in the amount of $2,500 plus OR in this case. There's still no bond in the other case, that won't change. service fee $171 prior to release of the usual condition. Ms. Adams, I didn't ask you to speak, so you don't say anything unless I ask you to say something. And that's the second time you interrupted me. Don't do it again. All right. Now, given that circumstance, this new case, what's the desire of the parties regarding procedural sentencing in the other case?
The state has no objection to today.
Mr. Wagner, do you want to know what's your position?
Your Honor, in light of the new case against Adam Maxwell, Prosecution Keith Maxwell, earlier about potential sins on this. I know the court being inclined, I think to delay this even further, but the new case is being arraigned. I know the court date set for the first next week. I can now find out a little bit more from my client. We go forward and sit for the court.
So we set for, I did set a pre-trial for this, so let's do this. Need to set anything for next week. Monday's the only full day I'll be here. How about Monday at 1 o'clock? Sure. Yep.
Yes, sir. Here's that would be.
All right. So we'll set as the first pre-trial for the 27th at 1 p.m. And then a final pre-trial will be set for July 6th, I think, 6 pre-trials. At 1 o'clock. And the trial will be set for August 9th at 8 a.m. We'll do first continue the sentencing hearing on the 117 case in progress. And that court may or may not proceed with sentencing Monday, depending upon what occurs at that time. That may happen. I don't wait and see. I'll listen to what everybody has to say, then make a decision. All right. Anything further, counsel? All right. Your attorney will be out to see you, Ms. Adams. All right. Who else is that?
That should be it, Judge.
Supposed to hear. See Ms. Price is there. The other two in jail?
No, sir.
No. Mr. Parsons is not. Mr. Rhodes is not. They're not those two. All right. So we'll go ahead and do Ms. Price then. State of Ohio versus this is case number 23095. State of Ohio versus Gary C. Price. Gary C. Price up here there from Northern Harris House.
Yes, sir.
All right. This hearing is being conducted by Zoom. This Price's attorney, William Armstrong, is present for court against another client that's here in person. Mr. Brooks. So I think Katie, you just appear here. I don't know if you see him or not. He's through the glass there. Not a very good picture, but then he's not much to look at anyway. So, Mr. King, on behalf of the state, is appearing by Zoom in his office. All right. The defendant has entered a plea of guilty to aggravated trafficking and fentanyl-related compound counts 1 and 3, both for felony support. Order for recent investigation, which I have received due. She was also referred to the drug court docket, and I do have a letter from the surgeon indicating she was screened and meets the criteria and is eligible for admission to the drug court docket. All right, Mr. King, anything that you would like to say?
Only those that they agree on restitution in this case, and they know that maybe.
All right, Mr. Armstrong.
I would ask the court to follow the plea arrangement, place carry on community control, accept her into the drug court. I understand she's doing very well. I spoke with her early on about the possibility of the drug court. She's very much in favor of it. She understands that it is a lot more intense than just straight probation, but that was what she requested. We'd ask the court to consider that.
All right, Ms. Price, I'll hear whatever you would like to say at this time.
I would like to like this program, with my husband. I have one from Cincinnati, I'm just thinking of Westboro, too soon. And then stay here, there's additional examination. So, we talk to whatever.
Now, the drug court is something that the court doesn't tell people to go into against their will. You have to apply for it. I do have your application. Is that still what you want to do? Okay. You understand that that's a commitment to focusing on sobriety and staying sober, and as a result, it's much more intensive than regular community control. In fact, you'll be appearing before me twice a month, including tomorrow, we have other people coming if I miss you. You'll be in it for a minimum of 18 months, more likely 22 to 24 months if you will. If there are any bumps in the road, it could go long. I can't keep you in for as much as 5 years. I haven't done that. Well, the only existence is a little over 3 years. But in any event, that's not safe. So if that's what you want to do, then I will admit you to the drug.
Thank you very much.
Right. Then the court does, this is a drug court, and it's ordered that you be put on community control under these conditions. First of all, you'll be under community control for a period of 3 years, minimum, or that's the minimum at this point. Could be up to 5 years in the future for terms that should be extended. And you're required to comply with all of the program requirements and conditions that you went over with Ms. Sturgill and signed and you have filed with the court. That includes a number of conditions I'm going to talk about now, and how you'll have to comply with everything that's in the program description and all the conditions of the drug court document. But that does include, without limitation, you must obey all laws, all jurisdictions, conduct yourself in all line manner at all times. You must report when and as directed. Be truthful in all statements given to the probation department, and answer the questions asked you about your conditions, including your treatment team. You're to keep your supervising officer informed of your residence and place of employment all the time. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you when you go out of state. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone within any of those facilities without prior written permission. Now, because of these convictions, you're prohibited under both federal and state law from purchasing, owning, using, or having under your control any firearm, ammunition, dangerous ordnance. To do so would be a felony in both state and federal law. It's also a condition not having of those during your community control, nor any other weapons of any other type. You're not to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD oil, created from any variant or analog of any controlled substance or drug abuse that has in fact similar to controlled substance, or drug abuse, or any instrument, device, or thing may be used to administer them or prepare them for administration, unless you have a lawful prescription. You must provide a copy of that within 24 hours of receipt. You're not permitted to obtain a medical marijuana card while on the drug court document. You must report, or you must submit to drug testing when and as requested by the probation department or the treatment team to be any of the providers. You're not permitted to purchase, possess, use, have under your control any alcoholic beverage, nor be present in place of the soul being consumed, even as otherwise lawful. Not to associate with anyone who's a co-defendant in this case, or any other person past, with the future, unless you commit a criminal violation or violate these conditions, unless that's approved in writing by your supervising officer. Have applied to any family member to fall within that definition, unless you live with them immediately before commission of this offense. After the date of this order, which is today, the 23rd of June, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without written permission. Thus report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide supervising officer financial information records or your ability to pay restitution, fines, fees, and costs for your review. If you're referred by the probation department or any other probation employee or treatment team member for further evaluation or assessment, or any other treatment, therapy, counseling, training, or educational programming, or submit that. If there's any recommendation for programming, then you're to enroll in and successfully complete that. We are required to comply with all the pay restitution through the victim witness escrow account. And around $180 paid with the County Task Force. That will also include any service fees that may be incurred for them processing those payments. And you're to pay that in 18 months. Now you're required to comply with the treatment plan that is recommended. Now, by being placed on community control rather than being sent to prison or being sent to serve a warrant or person, residence, vehicles owned by you or used by you, or any other property places under your control where you're found at any time in the office of the probation department. With no fine or private suspension imposed. If you don't pay your court costs, you're to pay those as a addition. Make payment arrangements to do that. If you don't, then the court first like that, the judge may include the level of bank account wages, earnings, and other assets that you may have. If that doesn't like it, then the court authority will do the service, give you credit, and it has to be in this county. Give you credit for each hour you work, in and out of this for each hour you work, reduce your judgment by that amount that they court. Now, in the event that the probation department feels that you have failed to comply with these conditions, they will file a record at the court. There will be a hearing, you may not have an attorney. If the outcome of the hearing is that you have failed to comply, then the court at that time could terminate you from the drug court docket and terminate you from control and send you to prison for a total of anywhere between 6 months, which is the minimum in each count they're going to serve currently, up to a maximum of 30 months. Which is the maximum, 18 months of count 1 and 12 of count 2 is the maximum. So sentence would be between 6 and 30 months and a fine of $10,000. I think that should occur. Once you complete that prison term, then the law provides that the court authority may, at their option, push on close release control supervision for a period of up to 2 years. And if they do, and you fail to comply with those conditions, they can return you to prison. Make you serve additional period of up to 9 months or one violation up to a maximum of half of the prison term was imposed for all violations. But if you are victim of new felony law under post-release control, then an additional represents the judge in the new case imposed upon you. The judge may also sentence you for committing that violation while under post-release control. In this case, to an additional period of 1 year, whatever time is left upon that 3 years of post-release control, whichever is greater. If that occurs, that has to be served. Secondly, the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, and your office of pre-trial supervision, those are the conditions. We'll be talking about probation, I'm sure, tomorrow, and we'll see you in the drug court tomorrow. All right, thank you.
Your Honor.
All right, Mr. King and Mr. Gross is present here in the courtroom for all right, and we'll just we'll meet on this if we have some more coming out here. In this case, under 22-079, State of Ohio, Josh L. that the Brooks, Fairhaven, United States, your case, Fairhaven, United States, Army Craft, are you, Josh,
Yes, sir.
what's charged with, aggravated possession of drugs, aggravated possession of methamphetamine, both are, 50 felonies. This, not three trials actually, I think, received last week, last week. And the trial date is 11/5 a.m. Now, looks like discovery has been complete, is that correct? Yes, sir.
John, you probably don't have it yet, but about half hour ago, I found an application for treatment in lieu. I've been aware of it for quite some time. So the state gave me that offer. Early on, Josh and I were talking about another positive resolution. Along with the application for treatment, the questions were filed, and in fact, he's already even executed the plea form, but he has not been assessed, Your Honor.
Okay. You're in. Where do you live, Mr. Rose?
102 Saucer Street, Green.
All right. Well, then you'll have to be assessed, so, you are to, report down to probation department then, as you get done here today, I'll order the assessment. The, July, trial date is vacated. And we'll set the matter for a, hearing, or a, NLC report, probation department. Mr. Bolton, does he see you or Mr. Archie on that? All right, so you stop down, Mr. Bolton's down there right now. Stop that, so again, we'll set the matter for hearing, August 3rd, at 9 a.m. Are you going to sign a motion to bailiff from Ron here on the 11th? And, go down to the neighbor also, and probably go to FRS, be assessed. So we'll get down there and make an appointment, make an appointment with FRS to get assessed. They recommend treatment, you should start treatment immediately, not wait until the day of here. Because, if you're serious about wanting to do this and getting treatment, then you need to start sooner, not later. And, it's to your advantage too. Because this gives you an opportunity to avoid having a conviction by going through this process and current knowledge. Anything further, Mike Council?
No, Your Honor, thank you.
All right, thank you. All right, then we have, next to Sean Rose, Tyler Rose, Clarkson, all my video.
Yes, sir. 2 o'clock. Yes.
Okay. All right, so we have 3 more at 2 o'clock, Mr. Bolton, on this week, next year, be back on record then. Hello? Hello?
Are you here for courtroom?
Yeah, my one paper said 1 and they changed it to 2 and I didn't realize there's a change in time, so I thought, I better give you 1.
What's your name?
Shannon Rhodey, it's at 2. It says, there's a little asterisk that says, notice time change, but I didn't see that until.
Did you know it was by?
Today.
Did you know it was by Zoom?
By 2?
Yeah.
At 2.
By Zoom?
Oh, by Zoom, no.
Yeah.
See, okay, so I should do that?
Yeah.
Okay,
You know how to do that?
I've done it before.
Okay, so we should have sent you that link. Okay.
This is, I just saw the time and I was like, ah.
But your email is sroad
Okay,
at
yes.
316 gmail.
Okay,
As soon as you check that, you should see the link on here. If not, give us a call.
okay. I had trouble getting on that email address, so can I still hop on another email address? If I give it to you?
What's another email address?
That's Shannon Rhodey, all lower caps.
Yes.
Watch out. I forgot the password. I'm terrible. I know it's spelled weird. No. It's all lowercase and then 10. Shannon Rhodey 10.
So we
Shannon
should-
is spelled weird like that.
So we should disregard this email then?
Yes, because I couldn't get in it.
Okay.
doubt it'll let me in now. I don't want to fiddle and do, yeah.
I'll be right back. Let me make sure this is okay.
Okay.
Here.
Okay, we're gonna send it to you, that new email, okay?
Okay. I didn't see anywhere that it says that, but as long as you say it, from within.
How long will it take you to get on that email?
Like 10 minutes to get home.
Oh, okay, perfect.
I think.
You're welcome. Clarkson,
He was here.
but we made sure he got his Zoom link.
That was Carter. Sarah's another, extra another, sure.
Brody?
All right, this case number 20 CR 219, State of Ohio versus Shannon E. Brody. You're Shannon E. Brody, hearing there, right? This hearing being conducted by Zoom, this attorney Sarah Barber, hearing by Zoom, and her behalf of state is King. The defendant was granted intervention in lieu of conviction by charge of aggravated possession of drugs on June 23rd, 21. Notification filed May the 20th, May the 20th, 22, terminate her for failure to comply. Court notified her on 3rd or 9th of June, 8th of June to set the hearing today, appointed Ms. Barber to represent her. Now, Ms. Barber, have you had an opportunity to review the allegation? All right. And does your client wish to have a hearing, or is she going to be admitted to the violation? Okay. All right, we'll do that. Hey, Ms. Rodham, I'm going to put you in this Barber into a room on the computer by yourself. No one else will be able to see you, period. There should be a button that says join breakout room coming up on your screen. Click on it. When you're done, it says, there's a button that says leave breakout room. Click on that. All right. We're back on record. All right, Ms. Barker, you had a chance to talk with your client. Okay. All right, well, Ms. Brody, you were put on an intervention rehabilitation program on September the 2nd of 2020. I misspoke earlier. I was misreading my notes. Then the motion to terminate was filed on May the 16th of this year. And the allegation in that is that you have violated Rule 4, that you failed to report since March 17th, 2022, and no contact with your supervising officer since that time. Rule 9, which were arrested on May 5, 2022 on a bench warrant out of political misreport for failure to appear. You failed to notify your supervising officer of that contact. Rule 10, that you were put into the call-in drug testing program September 14th last year, and only called in a total of 36 times since that's a daily call-in. And the last call-in on April 14, 2022, and failed to show a number of 30 times when you were selected for random drug testing under that program. Rule 11, you tested positive for methamphetamine and amphetamines on September 17, October 8, November 5, December 7, and January 11, March 3rd, and 17th, 2022. And finally, Rule 14, not made any payments on the court costs and the county surcharge. And it was signed by Officer Argila, who's also present on this call. Now, on this hearing. Now, you are entitled to have a hearing in that case of those allegations, which the state had presented testimony that proves the court's satisfaction you failed to comply. You can cross-examine the witnesses by your attorney. You can also have testimony presented on your own behalf. If you admit to the violation, then that means that the intervention will be terminated. You will be found guilty because your guilty plea has been held in abeyance pending the report. And that means that you will be subject to being sentenced to 6 to 12 months in prison, fine $2,500, and have a suspension of private suspension of 6 months to 12 or 5 years. You also could get community control. Now you understand your right to a hearing?
Yes, sir.
And you understand the consequences if you admit to the violation?
Yes.
Yes. All right. Does anyone promise you anything or threaten you in any way? Yes, you do.
Yes, sir.
All right, and are you admitting to the violations that I just went over with you that were filed on May 16th? All right. All right, the court then will find the defendant is guilty of the aggravated possession of drugs and terminated from the intervention in lieu of conviction program. The court will order an updated PSI, including an assessment for substance use disorder treatment and or mental health as determined by the department. We will set sentencing on this for August, I believe it's on the 3rd. Oh, that's right, that's Wednesday, oh, okay, you do that day? Well, if you do this early, then you can go to the hospital. Yeah. And get it. Well, let's do this then. How about, today is the 23rd. Okay. We won't need a full, time to get an update, so let's do July 7th at 1 o'clock. You need her to come into the office to schedule that, Mr. Bolton, or just contact you.
If she contacted me,
Alright, you have their phone number there, Miss, Brody?
Yes, sir.
Alright, as soon as you leave this meeting, you can leave as soon as you get up your case. Call the probation officer to get that appointment. Now, are you in any kind of treatment at the moment?
I'm so, yes, Happy Valley, I've completed, I think, 25.
Okay. Well, you'll just have to sign and release information so they can get that, to Mr. Fulton and, so that you can report, back to me. And, we'll have your hearing, on the 7th at 1 o'clock, and it'll be by Zoom.
Okay.
So make sure you stay in touch with everybody. You have any questions? All right, you can go ahead and end the meeting.
Okay.
All right, Tyler Groves. Case number 22 CR 083, Dave, Ohio versus Tyler Isaiah Groves. You are Tyler Isaiah Groves, appearing on the screen marked as Tyler Groves.
Yes, sir.
All right. Hold on here a minute. Mr. Clarkson? Mr. Clarkson? Hey, Mr. Clarkson? Can you hear me, Mr. Clarkson? Obviously not. All right. Mr. Clarkson, can you hear me? Mr. Clarkson? You are apparently muted. If you want to mute yourself, push on the button there at the bottom of your phone. It should say, like a microphone, it says mute, unmute. Mr. Clarkson? I'm going to take a break here. And he's in the car. He's inside. He's smoking. People that have okay. All right, we're going to go ahead and go on to Mr. Groves' hearing. Now, Mr. Groves' attorney is Sarah Barter, attorney by Zoom, and also the assistant prosecuting attorney, Adam King, attorney by Zoom. Defendant has entered a plea of guilty to aggravated trafficking methamphetamine in court for felony. Court ordered a pre-sentence report, and I have received that. And please, as part of that opportunity to review that report. All right. All right. Now, are you and your client agreeable with this hearing being conducted by Zoom rather than in person, Ms. Barter?
Yes, Your Honor.
You're all right with that, Mr. Groves?
Yes, sir.
All right. Anything to state regarding sentencing? All right, Ms. Barter?
His family even reports that he's doing much better, so just need this opportunity to stay on that good track.
All right, Mr. Groves, anything you'd like to say?
As far as the treatment, try to do that very well.
All right, and you are in the IOP program on aftercare at the Recovery Council?
Yes, sir.
Okay. And you're living, where are you living now?
1721 Newell Ridge.
Who do you live with? Who's living there with you?
My parents.
Your parents, okay. All right. All right. Well, it's the judgment of the court then that should be and hereby sentenced to a term of 3 years of community control in the supervision of the probation department. These are the conditions of your community control. Your bail laws, all jurisdictions, conduct yourself in all live manner at all times, must report when and as directed, must be true in all statements that you make to them, as well as any answers you give to them regarding questions they may ask you. You are to keep them informed of your residence, place, employment, all times, and not take either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's inmate enter the facility without prior permission. You're not permitted to purchase, possess, own, use, or have under your control any kind of firearm, ammunition, dangerous orders, weapon of any other type. And to do so would be a violation of both federal and state laws, and subject to being prosecuted in addition to being a violation of your conditions. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any adhering or analog of any controlled substance has effects similar to those or drugs of abuse, nor even have any instrument, device, or thing that may be used to administer them or prepare them for administration without prior lawful prescription, upon which must provide to the probation officer to get it within 24 hours. There is submitted drug testing when as directed. May not purchase, possess, use, or have under control any kind of alcoholic beverage nor be present places where the soul being consumed is otherwise lawful. Not associate with anyone who is a co-defendant in this case or any other person that has a criminal record, member of gang, or other criminal group, or any person has in the past or could in the future unless you commit a violation of these conditions, unless proven in writing by your supervisor, officer, complies with any family members that might fall within that definition of the for the commission of this offense. After the date of this order, you're not to marry or establish cohabitation or common marriage type relationship with another person under your commission. Must report any conviction, arrest, citation, or other charge violating the law not later than the next business day after that occurred. You provide your supervising officer financial information records so you will obtain any fines, fees, and costs of your review. If you are referred by the probation department for evaluation, assessment, or any further treatment or therapy or counseling or programming of any type, you submit to that. And if they recommend any programming, you enroll in and successfully complete that. Pay the court costs of this action and make payment arrangements to do that. Is there any restitution in this case?
There is none, Your Honor.
Alright. You are to successfully complete your substance use disorder treatment at TRC and any recommended action here. Now, by being put under community control rather than being sentenced to prison, you're deemed to consent to a search without a warrant of your person, your residence, or vehicles, or any other place where you're found, or any vehicles which are found under under control at any time by any officer of the probation department. You're required to pay a fine, will not be required to pay a fine, will be no driving suspension. The court costs will be paid, they pay rates to do that, if you fail to do that, the court like that, the direction to the level of bank accounts, will be attorneys. Other assets you may have, that doesn't apply to them, court authority to insurance, give you credit for each area work. In an hour race, that would for each area work, reduce your judgment by that amount to pay full. Now, if you are alleged to have violated these conditions and the probation department files written up that report, you'll be given a copy. There'll be a hearing, and the outcome of that hearing is that you fail to comply, and at that time, the court will order you could revoke your control, sentence you to prison between 6 and 18 months, fine you $5,000. If that happens, once you complete the prison term imposed by the court, possible under the law that the no authority would put you in close release control supervision for a period of up to 2 years. And if during that period of time they felt that you had failed to comply, they could return you to prison, make a certain additional period of up to after the prison term for one or more violations. If he isn't fair, he's going to get some money driving. I think he's bad. Okay, alright. Yeah, okay, yeah, I can see that now. Alright, anyway, I'm sorry, Mr. Groves, Mr. Clarkson's situation is a little disturbing. Alright, in the event that that happens, then, like I said, they could return you to prison, make you serve a period of up to 9 months, for one violation of the maximum after prison term for all violations. So if you committed a new felony, then an additional whatever sentence the judge in new case imposed on you, the judge should also sentence you, in this case, to an additional period of 1 year, whatever time left on that period, most of the control, whichever is greater that occurred, unless the certain consecutively the sentence in the new case. Alright, you're no longer under pretrial supervision, those conditions all over with, you need to report, when does he report, Mr. Bull? You're muted there, Mr. Bull. When do you want him to report to the probation department? Alright. next Thursday, then, Mr. Rose, and they'll go over your new conditions, okay? All right, you may go ahead. Pardon me? Oh, okay. All right, you can go ahead and sign off that leave. All right. Next case is State of Ohio versus Dennis Daniel Clarkson, 22 Sierra 102. Now, Mr. Clarkson, can you hear me? Mr. Clarkson? I can see him. I will note for the record for the past 10 minutes, he's been smoking, almost asleep. He's in a car. It appears to be driving. There's another person driving. He appears to be somewhat distressed at the court. And he was up here earlier and was told to get on Zoom, but he is not. Doesn't even appear to be capable. I don't know if his volume's on or not. Mr. Clarkson, can you hear me at all? I'm going to send him a chat and see if that works. Mr. Argina? You have his cell phone? Okay. Can you text him and tell him that we can see him, but can't hear him? I want him to report to you by the end of business today. And if you don't talk with him, then there was just lost him. Then I want him in the office by tomorrow and test it. He appears to have some issues. Mr. Clarkson, can you hear me at all? I cannot hear you, Mr. Clarkson. Can you hear me? It appears to be putting some earphones in. You need to unmute your microphone if it's muted, or turn it up. There should be a button there. All right. This matter is set for trial. On July 14th. I see that there's a proposed plead guilty form in here. I also see that probation that he reported and had a positive drug screen on the 7th was supposed to go to detox followed by residential treatment. Did he do that, Mr. Garcia? Okay. Yeah, he was supposed to be there the next day. All right. All right, Mr. Clarkson, if you can hear me, I want you to go to the probation department before 4 o'clock today. You need to get there right away because there's some issues here. You appear to have some problem going on here. I want you to see what's going on. Arjuna, if you can't get him into the office by noon tomorrow, let me know. File a notice with the court, and I'm going to order him to be picked up because he does appear. Are you there now, Mr. Clarkson?
Yes, sir.
Okay, well, number one, there's a whole bunch of issues here. First of all, take your hat off because you're in court. Earlier, you were smoking when you were outside, but you appear not to be in very good shape, Mr. Clarkson. So what I'm going to do is order you. Where are you, Beth, anyway? Where are you located in the car? What's your position? All right, well, you can turn around and come back to Hillsborough, go to probation department and get drug tested. I see here you were supposed to go to detox and residential treatment, and you didn't do that. And just the way you've been acting for the last 15 minutes while I was doing the other hearing and watching you, I have some real concerns about your condition at this point, whether or not you're even capable of participating in this hearing. So I want you drug tested, and I've already instructed the probation department, if you don't show up by 4 o'clock, they're to notify me, and I will issue a warrant for your arrest until you can be tested and we can see what your situation is, because I'll just tell you real plainly, you look really bad. You almost fell asleep there for a couple of minutes on screen when we were trying to talk to you. I've made a number of attempts to try to talk to you, but I have some real concerns about what's going on here, and based on what the report is from the probation department, it appears to me you need to be in the treatment facility and get detoxed for your own safety. So you turn around and come to Hillsborough and get to see Mr. Arjima before 4 o'clock. If you don't make it, there's going to be a warrant out for you tomorrow morning. You hear me? All right, this case will be continued, and we'll get in touch with you, Mr. Gardner, tomorrow. You think you can be around tomorrow? All right, we'll touch base with you tomorrow after we find out what's going on with him. But if he's positive, Mr. Arjima, they might want to see about taking him to detox time. He does appear to be very, you look really bad, Mr. Clarkson. I don't know you very well, but the way you've been acting, almost passing out, and acting like you weren't, even when you couldn't hear me, you just didn't seem to be right. So I'm real concerned about you, and this is for your own good. So you get yourself probation right now. All right? Yes, sir. All right.